My name is Robin Lee. Welcome to Buzz on the Bluffs, Vicksburg, Mississippi's Community Insight Program. We'll be taking a look at people, places, and events that impact our community. Thanks for joining us. Thank you for joining us today on Buzz on the Bluffs. We're glad to have Judge Chaney back.
Glad to be here.
Thank you for coming. You know, it was so interesting to have you here last time, and we got so much great response that I thought it would be nice to have you back. And we actually may break this up into several interviews so people can drink a cup of coffee at work and watch a quick interview and learn all about the circuit court.
Sure, I'm glad to.
So, good. I wanted to talk about jury service and how people get selected. You know, we get that notice in the mail and we get that sinking feeling in our gut.
Well, it shouldn't be that bad. And so what I try to, I explain to people when they show up for court, I said, let me tell you how you got selected, why this is your lucky day. And the juries are pulled from the registered voters of the county. And the Secretary of State has developed a computer program that randomly picks names. And so sometimes it can work out where somebody gets picked, you know, once every year, and their spouse or their neighbor across the street hadn't been picked in 2 or 3 years, and it's a completely random thing as far as how that happens. We do have 3 local jury commissioners, and they monitor the process. They check the computer program, make sure they're not pulling all names from with a letter L or not ever calling letters other letters. And so there's a guide that they go by to make sure the program's working properly. And so that's how people get the letter. Actually, it's a summons. But you know, jury service is so important. Our whole system of both criminal justice and civil justice depends on us having jurors who are willing to come and to serve and to offer themselves for service. And I understand that if anybody shows up, they're taking time out of their day. They could be doing something else other than that. And so I try to make a conscious effort to get that process going on time, to go through the selection process as quick as we can, to get the people who are selected and going to serve, get them identified, send the rest of them home. And then even when the trial's going on, I try to push the lawyers. You know, the jurors don't ever see that, but I try to push them. We're going to start on time. We're going to take breaks, but we're going to take short breaks because, again, these are people, they're getting paid $20-something a day, and so nobody's making money doing jury service. And it's so important that the law provides that it's not really a voluntary thing. It's a summons, and you have to come. The law provides that if someone is summoned and does not show up for jury service, they can be fined $500, they can be sent to jail for 3 days, or both. The law also provides that employers cannot punish their employees who respond to a jury service summons. They cannot require them to use vacation days or leave days. Now, they don't require that they give it, but if they have that kind of policy, you can't be required to use up your vacation or sick leave or personal days for jury service. And so it is important, it is required, but I like to emphasize the positive. And so when I am out and about and I see people, and you know, sometimes I hear stories on the internet, or somebody will be telling a story about some horrible jury verdict in some other state. And of course, my first response is, you know, everything you read on the internet's not true. And then secondly, you know, who were the jurors? You know, and so sometimes I find out that the people who are complaining about jury service or complaining about jury verdicts go through all sorts of hoops to try to get out of it. Mm-hmm. And so my appeal is, if it was you, if it was your business that either had a claim or was being sued, wouldn't you want someone like you on the jury? And then my second argument is, you know, if everybody who had a job, for instance, was excused from jury service, who does that leave to be making all these important decisions? And so, you know, if it got skewed like that, there might be a reason why sometimes, if it does happen, there are more outrageous jury verdicts. And so And so that's what I try to appeal, not to the punishment angle of it, but to people's own self-interest. And really the main thing is, we need a cross-section of all our community, and most of the time we get that. And so it's a good thing. And we're trying, at least I'm trying, to be very sensitive to the jurors' needs, and we try to get that process going, get the jurors selected. And then the other thing I've done is, I started 5.5 years ago, and when somebody shows up for the jury panel, I write them a letter and tell them how important it was for them showing up, thanking them for their service. It's not much, but it's some little something. Again, the money's no reason to come. I had a gentleman come up to me in the grocery store, and he looked at me and said, "Are you Judge Chaney?" And I thought for a second, well, I wonder where this is going, But
does he have a gun?
and I said, "Yes, I am." He said, "Well, let me come shake your hand." He says, "I was on a jury last year, and I got a letter from you. I've never gotten a letter from a judge, and I sure do appreciate that." And that made me feel good. Now, most everybody may throw them away, but if for some people, they know that I appreciate them doing their civic responsibility.
Well, someone told me that they were summoned for jury duty to your court and received a thank you letter from you, and they brought it to show me. This was before I had ever even met you.
Right.
Because it was very unusual, in a good way,
right,
that a judge would send a thank you letter to a juror or a potential juror.
Well, I try to do that. I got that idea from a judge in Tennessee at a conference one time. I said, that makes plenty of sense. And again, the pay is so small, it's really just barely covers expenses, but it is so important for people to show up. So let them know that I appreciate their service, trying to accommodate their schedule when we have the selection process, and then once the trial gets, is ongoing. Those are little things, but I'm just real sensitive, and I understand where they're coming from on the other side, and if hopefully we'll have more people cheerfully serve on
right.
juries.
Well, it's our duty as registered voters. I understand that.
It is.
But you do hear those horror stories. So tell me about when I get a jury summons and I report to your courtroom. What happens at that point?
Okay, as the jurors come in, they are greeted by the officers from the clerk's office and the bailiffs, and there's a little form you fill out that just has name and address and your occupation or former occupation, and so that information is compiled, and then they, of course, checking off the names from the larger list on the computer program of everybody who receives summons. Now, some people don't show up, some people have died, some people have moved away, and so I think there's an effort with the election commission and the clerk's office to help get the rolls more up to date and accurate. But anyway, you fill out that, then they watch a brief, I think it's a 10, 12-minute video that talks a little bit about jury service. The clerk then gets because the people come in at different times, if it's supposed to be 9 o'clock. And then the clerk gets them in order, so they'll be on the same order that their names were pulled on the computer program. And then I come into the courtroom, I give them a very brief introduction, and then we go over the qualifications that people have to meet in order to serve on the jury. And then I go over a list of possible excuses someone may utilize to be excused from jury service.
Well, then how do y'all start selecting who's going to be on the jury? I mean, how do you include and exclude? I mean, I understand that probably attorneys have a lot to do with that. And how are they deciding who they want and who they don't want? And do they have a number, like do they have X number that they can say, no, I don't want that one, and then it's kind of like timeouts, you run out of them?
Right. You ask a lot of questions.
I know.
I can answer a couple of those. Well, first of all, when we go through the qualifications, there's certain things. You have to be a registered voter. You have to be able to read and write. You cannot have been convicted of a felony. You can't have a case pending in circuit court at that time, and so I'm missing two more. Let's see. One, you cannot have been convicted of a sale of drugs or alcohol within the last 5 years. And you cannot be an habitual drunkard or gambler. And that's the one that usually gets a few chuckles. And so then I go to the excuses that are optional. And so if you're 65 years of age or older, you can elect to be excused. but you can still serve. And so sometimes I get really great jurors. I had one last week, 80 years old. Wanted to serve, and he could serve, and he did serve. But if you're 65, for no reason at all, you can say, hey, I'd rather not serve, and the law allows you to be excused. If there's some serious financial hardship, if there's an illness in the immediate family, those are optional excuses. Breastfeeding mothers can opt to be excused. If you've served on a jury within the last 2 years, you may elect to be excused. And that's just a benefit, for instance, that federal court does not allow. So, if you actually serve and you're picked and you help either serve on the grand jury or hear the case, then you're not going to have to come back in 2 years and be required to serve again. And so that's done first. And so that's done at the bench if anybody says, well, or if they're convicted of a felon. Anyway, all those things I read out, they come to the bench, we see if that applies. And so that some are excused every time for that. And then there's a process called voir dire, which I think is a French term that means to speak the truth. And so the court usually starts that process, and I ask if they know the attorneys, if you're related to the attorneys, if you're related to the parties, have the attorneys ever represented you, or have the attorneys ever sued you? Just trying to see if there's anything in someone's background that might cause them to unduly favor one side or the other before the case ever starts. The attorneys get to ask those kinds of questions too, depending on what kind of case it is. They might ask, have you ever had an experience either in a car wreck or shoplifting or whatever the case is about? And so the attorneys were making notes about all of those things. Then there's a recess taken, and so then the attorneys then meet with the judge outside the presence of the jury. And to get to your question, one of them is, how do they decide who they want and who they don't? That's probably a secret for each attorney, or they may have tendencies. They may like older women or younger women or working men or non-working men. So they've got who they think might be more receptive to their arguments or their case. And then on a civil case, you only have 4 strikes. And so first of all, they can say, well, gee, you've got strikes for cause. If somebody says, I'm the brother-in-law of this attorney, well, they can say, there's no way for him to be fair and impartial, and so he can be stricken for cause. But once we get through the cause, then they have each 4 strikes. For no reason at all, they can go through and say, I don't want these 4. And so if you look at it that way, once you get through the qualifications, once you get through the strikes for cause, then you've only got 4 strikes apiece. And so a lot of it is just how close to the top of the list you are as to whether you'll even be considered or not. In a criminal case, you get 6 strikes per side. Both the prosecutor and the defense get 6 strikes per cause. And the only exception is in a capital murder case, each side gets 12 strikes. And you have to draw a larger pool, and there are other issues that get involved. But that's pretty much, what's involved. That's what the jurors don't see. And then, so once we have gone through that, and then we get 2 alternates, just in case something happens to a juror during the course of the trial, they get sick or there's some emergency. We've got somebody else that can slip right in their place without having to call off the entire trial. So we usually have 14 jurors. 12 will be deciding the case, and you've got 2 alternates. And so that's kind of how they're picked, how they get into the jury box, for either a civil or a criminal trial. And that process works pretty good.
So then they hear the case, and then now it's time for them to make their decision.
Correct. And
so they go off into the juror's room.
Correct.
And hash it out. You give them instructions?
Yes. After we've heard all the testimony and the evidence, then I'll give the jury written instructions as to the law that they have to apply. And those have been something that have each side, the court has 1 or 2 standard instructions. Each side then submits instructions. And again, outside the presence of the jury, usually early in the morning before we get started, sometimes during lunch, depending on where the case ends, I'll go over with the attorneys their objections and additions or corrections to those jury instructions. But when the jurors come in, they are read the law to me. It tells them what all the plaintiff or the state must prove. It talks about if there are any defenses. It talks about how many of them have to agree. In a civil case, it's 9 of the 12 have to agree for there to be a verdict. In a criminal case, all 12 have to agree. And then there's a form of the verdict. So I read those instructions to the jury, and then the attorneys make their closing arguments. And I explain to them, have already explained to them once, I usually do it twice, that what the lawyers say is not evidence. They're just trying to help them refresh their recollection, help them apply the facts to the law that applies in that particular case, but they're to use their own recollection of the facts. And the important thing that the jury does, they determine what evidence is more credible or not, what evidence is relevant to whatever the issues are. They can believe part of someone's testimony or none of it, and they use their good common sense, their experience, their good judgment in making that decision. And the jury almost always has the exclusive duty to decide the contested issues of fact. Mm-hmm. And sometimes that can be, was the light green or red? Or it can be, did somebody have the intent to do whatever it was if it was a criminal case? But so the jury decides the facts, and then the court gives them the law, and they mesh those two things together and come up with a verdict.
Well, as we wrap up, the one question I wanted to ask you real quickly, when I've seen some of these high-profile cases on TV, and then after they come up with the verdict and everything's all said and done, those jurors go on TV and talk about all of this. And it seems to me like that should be confidential information. Is that public record? Are they, obviously they're allowed to go out. I mean, they're interviewed on Good Morning America and all these shows
right.
about what went on behind closed doors, and that always seems wrong to me.
Well, if you talk about a high-profile case, or if it's one in California or New York, they may do things a little different there.
Yeah.
Here, I really stress at the front end that they're not to discuss the case, not even among themselves, until the case is over. And I explain to them why, that they need to, you hear one witness or two witnesses, you might be leaning one way, but you don't need to really be talking about that until you have heard everything. Mm-hmm. And then, obviously, in the jury room, they're discussing and talking and recollecting and talking to each other, and I don't hear that. I mean, that's just among the jurors. And I tell them, stress to them, that they cannot talk about the case with anyone, and talk includes texting and emailing. And
even after it's over?
No, just while it's going on. But once they have reached a verdict, and right before they are excused, I then tell them, if you want to talk about the case now, you can.
And they can.
But you don't have to.
Mm-hmm.
And then I tell them, because there have been instances, I don't think here, but other places, where jurors have been harassed. Somebody's been bugged and tell me, mm-hmm. who said what or what happened. And so I explain to the jurors, if you want to talk about the case, if you want to write or share your experience as a juror, you are certainly free to do so. But if someone asks you and you tell them you'd prefer not to, and they persist, then they need to let my office know, or the mm-hmm. sheriff's office, and we'll make sure that ceases, because I don't want any juror to be harassed or badgered about what happened. Sure. But if someone wants to talk about it, they can.
They can.
When they're through and the case is over,
it's public record at that point.
Well, it's not public record
yeah,
until they say something.
Right.
If they
gotcha.
want to, they can.
Okay, well, thank you. We're going to record a couple more, but we're going to tie this one up and go on to another one.
Enjoyed it.
Thank you.